So your computer is going to ask you probably if you give us permission to record this. We would like to record it, please, because we'd like to load it onto our website so that other people can benefit from the information that we're going to share with you tonight. So thank you very much for being here, and by saying yes that that you agree to the recording, we're going to also ask you to agree to this video being loaded onto the website. If you're uncomfortable with it, you're most welcome. Here's somebody else coming in. You're most welcome to hop off, but submit your questions beforehand, and then watch the recording afterwards. Hi, Dario. Welcome to the to this chat, right? Okay, so Kath is going to present to us for a while. Kath, how long do you think that this is going to take? It's going to take around 40 minutes.
Yeah, not even. So I'm going to be chatting to you for maybe 15, 20 minutes, if that, and then we can literally turn it over to questions. So, okay. So Regina, is that you joining us, Dario? So Dario is actually Regina.
Okay, cool.
Yeah.
Okay, that's cool. Great.
And yeah, for like 15 minutes, and then we can have questions.
Okay, brilliant. And then if you have any questions that pop to mind and you want to jot them down, you're welcome to put them in the chat. Kath and I will just keep an eye on the chat. And if she's able to then answer while she's talking, she will. Otherwise, she'll answer towards the end. And then you're welcome to put your hand up, off mute yourself, show us who you are on video, and ask your question face to face. And if you can put your video on, that would be great. It just makes it a lot easier and more interactive and more kind of connect better if we can see your faces and your expressions. So that would be really nice, but up to you. Okay, so I'll hand over to Kath. Thanks very much.
Okay, hi everybody. For those of you who don't know me, my name is Kath McCormack. I'm currently on holiday and I'm sharing a house with 4 other adults, 5 children and a dog. So everybody's trying their best to be super quiet, but if you hear some noise, I'm sorry, there's just no way around it. So I'm Kath McCormack. My daughter Ella was diagnosed just before her 2nd birthday with juvenile arthritis. That was back in 2010. She's now almost 14. And together with an amazing group of volunteers, I run Arthritis Kids SA, which is a patient advocacy and family support organization, which you're all very familiar with, but that's the introduction in case you weren't familiar. So this evening, what I want to talk about is the intersection of patient rights and medical scheme rules. And it's an area where there is a lot of misinformation, there's a lot of confusion, and there's also a lot of fear. And that's not only among members like us, it's also among doctors. There's a lot of fear that if you take on a medical scheme, they will somehow penalize you or take it out on you. And that fear, as I say, is pervasive. So my objective this evening is to try and replace some of that confusion and misinformation and potentially fear with some facts, so that you know exactly what your child's rights are, what your rights are as a patient, but specifically we're talking about children with juvenile arthritis, what their rights are, and how to recognize scenarios where you can take on the medical scheme where they haven't met those rights. Because the reality is that the point where medical scheme rules intersect with patient rights, the patient rights always win. And that's something we don't know as South Africans, and we as South Africans, we don't fight for. We have to become significantly better at advocating for ourselves. And that's part of this process, is learning when we are allowed to and how far we can push. So the reason I'm talking to you about this is not because I'm a lawyer, I'm not, but I had a go in around March last year with a case to try and help a single mom whose child had been denied access to a biologic. A biologic, for those of you who don't know, is a specialized treatment that some children, about 20% of children with JAA, will need at some points in their treatments, in the course of their disease. And I had done some research, I'd done some reading, and I decided to give it a try, and we won that case. And since then, I have submitted almost 30 more cases, and we haven't lost one yet. And that's not because I'm especially clever, and it's not because I've got some sort of hidden legal talents. It's because the law is unambiguous, and because that law is enforced by a regulator that has the authority and ability to enforce it. And that's the Council for Medical Schemes. Anybody can do this. It's a little bit finicky, and it does require you to feel confidence about some of the facts, but anybody can do this. Having said that, I will continue to do it completely free of charge for all children with juvenile idiopathic arthritis. So if at any point you are battling with your medical aid, in the law, it's called a medical scheme. So if I say scheme, it's the same as a medical aid. If you are battling with them, they're not funding any part of your child's juvenile arthritis care or treatment, please feel free to get hold of me, and I will absolutely assist you. All right, so I'm going to jump right in, and I want to give you a sense of the laws that I'm referring to. There's the Medical Schemes Act. It's been around since 1998, so it's been around for some time. And then in 1999, they published the regulations in support of that act. And I'm going to speak specifically to the regulations. And in particular, I'm going to start with Regulation 8. So regulation is another word for rules. So these are the rules that all medical schemes in South Africa have to abide by. And Regulation 8 of the Medical Schemes Regulations talks about PMBs. And PMBs are prescribed minimum benefits. And I'm going to tell you exactly what that is. But what you first need to know is that juvenile arthritis is a prescribed minimum benefit. It falls under rheumatoid arthritis. They call it juvenile rheumatoid arthritis. It's an outdated name. It doesn't matter. It's a PMB. And what Regulation 8 says is that medical schemes must fund in full all diagnosis, treatments, and care costs for all PMBs. Now, PMBs includes all medical emergencies, 271 medical conditions, 25 chronic conditions, of which rheumatoid arthritis is one, plus HIV. So the financial burden of funding all diagnosis, treatment, and care costs for all of those conditions is enormous. And it could quite easily topple even the best run medical scheme in the country, which at the moment is Discovery in terms of its size and financial strength. So what the medical schemes laws, the Medical Schemes Act and the Medical Schemes Regulation, what they do is they allow the medical schemes to manage these costs through tools like formularies and protocols and designated service providers and pre-authorization. Now, you may have encountered these terms or you may not. I'm going to give you a brief sense of what they are. A formulary is literally a list of medicine that the medical scheme will pay for. So if you're on a particular type of plan and you have a particular disease, that medical scheme will say, these are the medicines that we will fund in full. Anything not on this list, we will fund either partially or not at all. And if they fund it partially, it means that they're going to include a copay, and that is the portion that you pay. So you're co-paying for it together with the medical scheme. So that's what a formulary is. It's a list of medicine they will pay in full. A protocol is the order in which treatment should happen, or it's the number of something that they will pay for, the number of blood tests, the amount of physio, for example. Designated service providers, I think we're all familiar with. It can include hospitals, pharmacies, doctors, healthcare professionals of any kind. And then pre-authorizations, I think we've all done, if not for our children, probably for ourselves. That includes all hospital visits. And these, as I said, these are tools that the medical schemes are allowed to use so that they can manage the cost of Regulation 8, which says that they must fund in full all diagnosis, treatment, and care costs for all PMBs. So now this combination of PMB cover combined with cost management tools works out fine for most patients. So let's take an example of a child who's diagnosed in Johannesburg with juvenile arthritis. And that child gets to see a pediatric rheumatologist who is contracted to his medical scheme. And that means the medical scheme and the doctor have a payment arrangement, and the doctor charges the medical aid rates. And let's say that child is prescribed methotrexate, and he responds beautifully to the methotrexate, and he never has to move beyond the methotrexate. And because he's responded so well to the methotrexate, his disease is well controlled. And so he doesn't have a very high need for physiotherapy or occupational therapy or play therapy, because they got it quickly, diagnosed early, got the right treatments, and the child is doing fine. So now the child has not been disadvantaged by these cost management tools that the medical schemes are allowed to use. But let's say a child lives where I live, which is in Knysna, for example, and the closest pediatric rheumatologist in Knysna is a 5.5-hour drive away. And let's say that this child with juvenile arthritis in Knysna tries methotrexate and it doesn't work. And then they try a different medication, one of the other DMARDs, and it doesn't work. And they try a third DMARD and it doesn't work. And this child needs a biologic. And without the biologic, their disease symptoms will not be managed. And because their disease persists for such a long period of time while they're trying these different medications, they have a very high need for physiotherapy. Plus the trauma of not being able to move and go to school means they also need a lot of psychotherapy because they're battling with anxiety and stress. And the parents are also feeling freaked out. And overall, this family needs a whole lot more treatments and a whole lot more therapy. Now, in that scenario, the law has created a circumstance where the medical scheme can't meet its legal requirements to fund in full the diagnosis, treatment, and care costs of the PMB. And that's not the purpose of the law. The purpose of the law is not to create pockets of people for whom the law doesn't apply. So in these cases, what the medical scheme regulation does is it creates management for the management. And this is in Regulation 15. So Regulation 15H and 15I, which deals specifically with protocols and formularies, say that for specific people where there are no other options or where the options have either caused adverse effects like terrible side effects or where those options have or would cause harm, those people must have their treatment or their specialist or their therapy funded even if the scheme rules don't allow it. So let's go back to the child in Knysna who was diagnosed with juvenile arthritis. That child's biologic must be funded in full, even if the parents of that child only have a hospital plan. It doesn't matter that the hospital plan specifically says in the brochure for the hospital plan that biologics will not be funded. It doesn't matter. That child has no other available options. They have a PMB condition, chronic disease, and therefore the biologic must be funded. So what PMB law doesn't mean is that because you've got a PMB or your child has a PMB condition, prescribed minimum benefit, it doesn't mean that you can go to the most expensive doctor in the country and use the most expensive treatments and go to all sorts of additional therapy because you think it's going to make sense and you think it's going to make a difference. That's not what it does. It's not to allow people with these PMB conditions to take advantage of the medical schemes. The purpose of the PMB law is in fact to create continuous care but cost effectively so that people with these conditions are able to continue living. Regulation 15H and 15I make allowance for people that have no other options. Now, I'm not going to go into the detail of how you recognize whether or not your child has an option for another treatment or not. It's quite complex, and ultimately that part will be done by your doctor. Now, I've written 2 guides on understanding the Medical Schemes Act, the medical schemes regulations, and understanding particularly
I think Kath is frozen. I can see from Natalie.
Oh, yeah, I wanted to say I'm missing something.
Okay.
will no longer apply.
Okay.
How
Kath,
do you know?
Kath, sorry to interrupt you. We lost the last 30 seconds of what you were saying. Can you start off from where you said that you've written 2 guides?
I can. Is my signal better now?
Let's try. You completely froze, so it can only be better. Maybe could you turn your video off just for 30 seconds?
There you go.
Might help. Okay, great.
Okay, I'll keep it off for a while and then I'll try again later. Okay, so I've written 2 guides. The one guide is for patients and parents and the other one is for doctors. And if you're interested in understanding how to recognize scenarios where the scheme rules no longer apply, then read the doctor's guide because I go into quite a lot of detail about that there. But ultimately, you're not going to be able to fight for patient rights that trigger these regulations without the help of your doctor. That's primarily because the doctor has to motivate for the treatment. It has to be an appropriate treatment by an appropriate doctor. And I don't want to go into too much detail because it gets very confusing. Your doctor will help you. And if your doctor doesn't know about this, you're more than welcome to refer them to me and I will send them the guide, or I will just talk them through it, or I will arrange some kind of training. But the doctor will help you determine whether or not the scheme rules do apply or don't apply. And again, the scheme rules don't apply if they are in conflict with the patient rights or your child's patient rights. All right, so just a quick recap. Regulation 8 deals with PMBs. Juvenile arthritis is a PMB. All subtypes of juvenile arthritis are PMBs, assuming they've been coded correctly. And again, that's something for your doctor. And PMBs must be paid for in full. No co-payments, must just be funded in full. But that doesn't mean that you get to choose your doctor, choose your medicine, and choose how much therapy you want. It means you have to do it within certain cost management tools. And that allows the medical scheme to tell you which medicines they'll pay for, which doctors, hospitals, and pharmacies they'll pay for, how much they'll pay, and also tell you where you must ask for pre-authorization. But if you ever get to a point where the scheme rules prevent your child from accessing diagnosis, treatment, or care costs for their PMB, then that's when you take it to the Council for Medical Schemes for assistance. Because at that point, the medical scheme rules, no matter what the scheme says, and they will never, ever acknowledge this, ever. I'm about to submit my 30th case. Not one scheme has ever acknowledged that this is their responsibility, despite the fact that I've won all the cases. They will continue to tell you that they will not fund a biologic, or they won't fund additional physiotherapy, or they won't fund additional blood tests. It doesn't matter. If the scheme rules are in conflict with the rights of the patient, as determined by Regulation 8 of the medical scheme regulations, then the scheme rules no longer count. And that's what you just need to remember. Are my scheme rules making it impossible for my child to have their PMB rights met? That's the only thing you need to remember from tonight. If you're ever in a situation, whether it's about blood tests, or it's about physiotherapy, or ophthalmology bills, or doctor bills, anything at all, and specifically treatments, especially if it's a biologic, because they cost an absolute fortune. If you're ever in a situation where your child has no other option and the medical aid still won't pay, then you've got a case. And at that point, you're going to go to the Council for Medical Schemes, or you're going to come to me. And the reason I continue to provide this service, despite the training that I'm doing now, is because the first time you do this, it takes a lot of confidence. An organization like Discovery is huge, a huge, big corporate organization. They've told you in no uncertain terms that they have no intention of funding your child's treatment. And it takes some confidence to go up against them. They use strong language. They are insistent. They don't back down no matter what you say. And it takes confidence. There's also the fear that I spoke about in the beginning, that if you do fight them, will there be retaliation? I've had so many parents say to me, well, what if they take away the funding that they've already given us? Are we putting our existing funding at risk if we force them to fund this? There is a lot of fear and a lot of uncertainty about how far these things can be pushed. And that's why it can be very helpful to work with someone who's already done it. But as I said, anybody can do it. And if you want to do it yourself, but you just need a helping hand, I can also do that. Okay, so if you decide to do this yourself, I'm going to briefly talk you through what happens. Your doctor will need to provide you with a motivation, and they will need to support their motivation. So let's say we're dealing with biologics, because 9 times out of 10, that's what we are talking about here. Let's say the doctor has prescribed a biologic. Your child has already failed on 2 or 3 other treatments. The medical scheme has assured you in no uncertain terms that the biologic will not be funded. And you have realized that your child's patient rights are now being infringed by the medical scheme rules. Your child has no other treatment options. They've already failed on 2 or 3 other DMARDs. They have no available treatment options. The scheme rules now no longer apply. That's what Regulation 15H and 15I say. So at this point, your doctor needs to give you a motivation, and they need to support the motivation with evidence that the child's disease is not sufficiently controlled. So that might be blood tests. With juvenile arthritis, it frequently isn't, but it might be. It might be some kind of scan, an MRI or an X-ray or a sonar. It might be just the doctor's report from a physical exam. The doctor needs to motivate, and the doctor needs to support. Now, if you come across a doctor, because not all of our children are treated by, not all of our, I'm going to try my camera again. Not all of our children are treated by pediatric rheumatologists. So if your doctor, your child's doctor, tells you that there's no hope and that you have to upgrade your plan type, you need to refer that doctor to the doctor's guide, which is going to go up probably on our site soon, probably next week sometime, or you need to refer them directly to me. Far too many doctors continue to tell people that they have to upgrade their plan types, which drives me crazy, because we are talking about families who are already very stressed. We're talking about children who haven't responded to treatments, so stress levels are through the roof. And now the doctor is placing the family under tremendous financial pressure by asking them to upgrade to a plan type that they can't afford. If you encounter a doctor who tells you that medical scheme rules trump patient rights, refer them to me or refer them to our website. It's absolutely not true. It's not, doctors don't do it on purpose, they don't know. And they have for years and years and years been told the same thing by medical schemes. And at a certain point, we all start to believe it. A year ago, if you told me that biologics could be funded on a hospital plan, I would have told you were crazy. And that's what most of us believe. All right, once you've got all this motivation, the very important thing is to apply to the medical scheme, apply to the medical aid, even if the doctor assures you that they're going to deny your application. And the reason this is important is because you can't go to the Council for Medical Schemes unless you can show that A, the medical scheme has declined your application, and B, that you've tried to resolve it with them directly. Those are the two things that you have to do before you can go to the Council for Medical Schemes. And the Council for Medical Schemes, just so that everybody's, just a reminder, they are the regulator. So they are the people who will enforce the law. They are the people who make sure that the medical schemes follow the law the way they're supposed to. They are the big brother overseeing everything that goes on. You can complain to the Council for Medical Schemes either via their website, and the process is detailed beautifully on their website. It all makes perfect sense. It's not terribly complicated. You can do it via the website, or you can actually, from me, if you want to, you can get the word-based form, which I find easier because I like to email my complaints together with all the attachments, and it just gives me better control over the process. If you submit it online, it sort of disappears into the ether and you have no idea if it got to them or not. A complaint to the Council for Medical Schemes is always decided on the medical merits of the case, not on the legal. The law is absolutely crystal clear. It comes down to the medical merits. And if you lose a case, it's because you didn't prove the medicine. So if your doctor hasn't motivated correctly, or if your doctor can't show that the treatment they are prescribing is the most appropriate option for your child at this time, then there's a good chance that you'll lose the case. And that's the way it should be. If medical schemes, these medicines are massively expensive. The intention is not to place the medical schemes under additional financial burden. The intention is to get the medical schemes to follow the law. And at the moment, there's no other way of saying it. They continue to behave unlawfully in this regard. There is not a single piece of medical aid communication, brochure, or website copy that I've seen that mentions any of the managed healthcare regulations. Not one. And as I said in the beginning, 30 cases in, hundreds of emails to and from medical schemes, 6 rulings from the Council for Medical Schemes in my favor. Not one medical aid has admitted that they had a legal responsibility to fund the medication that they inevitably, in fact, always end up funding. It's a bizarre situation. And I'm going to come back to that. It'll be my last thing that I talk about. And then the other final thing to say is that if your child's case is clinically urgent, then you should flag it as such with the Council for Medical Schemes, because while they are effective, it is a super slow process. It can take up to 7 months for the whole thing to play out. So if your child is desperate for a biologic, Lara, I'm just going to turn my camera off again because it says my internet's unstable. If your child is desperate for a biologic, you can't possibly wait 7 months, and your doctor and you must then flag it as clinically urgent when you get to the Council for Medical Schemes. So again, I can do all of this for you, or I can hold your hand through it, or you can do it yourself. I just want to say one last thing. I remember I did a talk very similar to this at the rheumatology representative organization in South Africa is called the South African Rheumatology and Arthritis Association, SARA. And there was a SARA conference a couple of weeks ago, and I did a talk very similar to this one. And I was rehearsing to my 11-year-old son, and I got to the point where I spoke about how medical schemes continue to behave unlawfully. And he said, but that's ridiculous. If it's unlawful, why do they continue to do it? And I mean, that just cuts to the absolute heart of it. And I can't give you an answer just yet, but what we have initiated is a very large project covering many of the biggest medical schemes, where we have accused or made an allegation that these schemes routinely dismiss or overlook the law in processing applications for treatments that fall beyond formularies. In other words, treatments that are not included in the list that they are happy to pay for, and that they're doing this routinely, and that the processes have to change so that all applications, regardless of plan type, are assessed not only in terms of the scheme rules, but also in terms of the medical scheme regulations. The Council for Medical Schemes has constituted a special team comprising multiple divisions within the Council for Medical Schemes, and they have gone to all of these medical aids. They have had meetings with them. They have investigated my allegations, and they are in the process of formulating a report, and then they will issue a memorandum to medical schemes to remind them that it is their legal responsibility to comply with all regulations in the medical scheme regulations. So ideally, what I've currently been doing, what I've been doing up until now, which is submit these complaints, ideally, if it all works out, I won't have to do that anymore. Nobody will, because all schemes will assess all applications the way they're supposed to be assessed. And that will benefit anybody with a PMB, not just rheumatoid arthritis. That'll cover lupus, and it'll cover type 1 diabetes and a whole host of other PMBs. But we'll see. I suspect this will still take some time. The other thing I just want to say very quickly, because it's relevant to JIA, is the medical scheme can't enrich itself or save money at your expense. So if they are refusing to pay for let's say, an ophthalmologist because your child perhaps has JIA-related uveitis, or because you need to screen for uveitis, and the closest ophthalmologist with JIA experience doesn't charge medical aid rates, and so they only refund you, say, a third of the doctor's bill, ask them where the closest ophthalmologist with JIA experience is. And if that person is 50 kilometers away, there is absolutely no way that they cannot pay the more expensive ophthalmologist. They can't save money at your expense. They cannot require you to drive for 45 minutes to a doctor that charges medical aid rates just so that they can save money. And that's the way that the medical scheme rules and laws protect us. Because we accept everything the medical schemes tell us. They tell us that they will only refund you 25% of the doctor's bill. We say, well, those must be the rules. And you sort of ask a question and they always come back with language that is hard to get around and intimidating and quite overwhelming. The medical schemes cannot save money or enrich themselves at your expense. So that, combined with have my scheme rules made it impossible for my child's PMB care and treatment costs to be met, those are the two things you need to remember. Because if you answer yes to any of those two things, then you know that you can take on the medical scheme to get better support. So I'm going to stop talking now. It's a lot of information, and it can be overwhelming the first time you encounter it. So I don't know if you have any questions now. You're welcome to ask them, or you're always welcome to come back to me with a question if it suddenly pops into your head 2 days from now. We got any questions?
Okay, so Kath, thanks very much. That's fantastic information, and good luck with fighting the cause. If you could turn your camera on, that would be great. Let's see how that goes. And
all right, well, it just keeps you. I'll try.
Okay, cool. Thank you. And I think this recording, we're recording this session, and our plan is to put it on the website. So if you do have any questions, please ask them now, because chances are that your question will be relevant to somebody who watched this recording later. So, so it would be very helpful to just explore this a little bit further. But like Kat says, if you do wish to pop her a message when you do remember something, or at a later stage, you're welcome to do so. Any questions or comments? No. Thanks, Natalie. If anyone wants to go after Natalie, please just raise your hand, and we'll ask you to go next.
Just to say thank you to Kath for all that information. We're just not made aware of all these things. And luckily for me, my child follows the easy route, the methotrexate route, and you just don't know. So first of all, just say thank you. And then with regards to medical aid, silly question. If I'm in my self-payment gap and my child requires medication, am I still liable for that? Because at the end of the day, you don't even question it. You just pay and you wait. So should I be paying for meds when I'm in my self-payment gap, or should I just be submitting to medical aid and getting it sorted?
Actually, that's such an excellent question. For juvenile arthritis and any PMB, those meds cannot be paid out of your medical savings accounts. And if you're in your self-payment gap, they still have to be paid. The treatments and care costs for juvenile idiopathic arthritis, all treatments and all care costs must be funded in full by the medical scheme. So if you're in your self-payment gap, they must fund that. You other things you will pay yourself because you're in your self-payment gap. But if it relates to treatments of juvenile arthritis, the medical scheme must pay it in full within those rules that I've described.
Yes.
But if the treatment then doesn't apply, if the rules don't apply because of the other circumstances I've described, then they must pay over and above. But if, for example, you're in your self-payment gap and you've got routine blood tests that are required, or you've got some physio, or you've got your methotrexate going off or whatever, that must continue to be paid by the medical scheme. It's not paid by the medical savings and it's not paid by the member if you're in a self-payment gap. Excellent question.
Thank you very much.
Okay, thanks, Natalie. And then we have Leandre, who asked just in the chat, Kath, with blood tests and ped room visits and ophthalmologist screenings, my medical aid caps me at the number a year. Is that permitted? Okay, and then we'll go to you, Dario.
Okay, so Leandra, that's also a very, very good question. So that falls under protocols. So the medical scheme is saying, here's how we think this should be treated. So in a year, we think that a child with juvenile arthritis should have this many blood tests and should see the doctor this many times. And that's completely fine, unless the child needs more, and the more can be justified by the doctor. So I had one of the cases I had was a child who needed significantly more blood tests. There was a child with systemic juvenile arthritis. The juvenile arthritis disease activity was through the roof. This child needed to have monthly blood tests, and they were capped at 6 a year. We took the medical aid to the Council for Medical Schemes and we won. Right, so it comes down to exactly the same thing. If your child requires additional blood tests over and above what the benefit allows, their plan type benefits. So think of your plan type as having a basket. And in the basket is all the blood tests and the meds and the physio and the doctor's bills and everything that they will pay for, that they're prepared to pay for your plan type. That's fine, unless your child has a need that falls outside of that basket. So if your plan type allows for 4 blood tests a year, but your child needs 7 because they've started on a medication that places their kidney and liver under function under stress, and the doctor requires to know if their kidney and liver function is fine, then the doctor can motivate for that to the medical scheme, and the medical scheme must pay. It just has to be motivated. So the ophthalmologist, the ophthalmology screening is required by the pediatric rheumatologist, who can write a letter in support of those ophthalmology appointments. And then the medical scheme must pay. So you can't make them pay for something that isn't motivated or justified by the doctor. You can't decide that you want to do blood tests every single month because you want to have the peace of mind that their kidney and liver function is fine. You don't have a leg to stand on. But if the doctor writes a letter to say this child requires additional blood tests, this child requires an ophthalmology screening every 3 months because they're taking hydroxychloroquine and that places them in additional risk for uveitis, then the medical scheme will pay. I mean, let me rephrase that. The medical scheme will refuse to pay, and then we will take them to the Council for Medical Schemes and they will force them to pay. And what's more is that we can also force them to refund you for anything that you've paid in the interim. So if the medical scheme has refused to fund something that you absolutely had to get and you paid yourself, you make sure to keep note of those invoices, and I will simply add them to the complaint and we'll get them refunded. That's happened in 3 cases that I've taken to the CMS, and there was no problem there. If your child needs something outside of the basket and that need can be justified by the appropriate medical professional, the medical scheme will have to fund it. I hope that answers. Great.
Great. Thank you. We'll go to Dario. Kath, just out of interest, how far back can you go with those refunds that haven't been paid in the past?
It's an interesting question. You can probably go back to the beginning. I have been quite tempted to sort of, Ella was diagnosed in 2010. I'm quite tempted to sort of go back over the years and say, oh gosh, look, there's 60 grand owing to us collectively over 10 years. I don't know. You can probably go back as I have no idea what the answer is. We'd have to test it. But there's no reason to say that based on misinformation from the medical scheme, I truly didn't believe that these costs could be refunded. And now I know differently. And actually I hold the scheme accountable for that. And I'd like them to refund me, and here are all the invoices, and here's all the evidence that I ever needed.
Good points. Okay, cool. Thank you. Then we'll go to Dario or Regina. Please, if you could put your camera on, that would be great. Okay, thank you.
Yeah. Hi, hello. Sorry, I'm working off an iPad, so it might be a little unstable to hold it. But Catherine, thank you very much for a very informative presentation, which myself and Regina were very impressed by the detail, etc., and your commitment. So thank you very much for that. I have two questions. The one is, in order to be able to be in a position to argue for these benefits, do you first have to be registered for, does your child have to be registered for chronic medication? I mean, our daughter was diagnosed in January, and so we've been paying out of our medical savings up to now. So I suppose that's the first step. The second question is, if the medical scheme appeals, as I think they frequently do, the Council of Medical Schemes decision, would your entitlement to that have to wait for the appeal, which can sometimes take quite a long time, I believe? Thank you.
Okay, so two parts, and I might turn my camera off. I think my internet is going again. So the first part, juvenile arthritis is a PMB. So yes, right off the bat, it is very useful if your doctor immediately applies for chronic benefits in support of the PMB. But JIA is a PMB, and that is regulated by the Department of National Health. It is reinforced by the Council for Medical Schemes, and it is not something that the coding that your doctor on the script that goes through the pharmacy that ultimately goes through the medical scheme indicates that your child has a PMB. So simplify your life completely by asking your doctor to apply for chronic meds for your child's PMB right from the beginning. But if you want me to help you go back and refund costs from your MSA and put them into chronic, I'm more than happy to give that a go. And I can't imagine that we'd have much difficulty, because it is a PMB and that's recognized. The second part of your question deals with appeals. So the Council for Medical Schemes process goes as follows. You submit a complaint. They take a couple of days to acknowledge that complaint and make sure that you've submitted all the necessary documentation. And once they acknowledge the complaint, they give you a case number and they send your complaint to the medical scheme. The medical scheme then has 3 months to reply. If they persist in not funding what you've asked them to fund, it gets handed over to a different team in the CMS. For example, the Clinical Review Committee, which deals with medical matters. So they establish whether or not there is a medical basis for funding, for example, a biologic. They give themselves 3 months to do that. So at this point, we're 4 months in. And at that point, they issue a ruling. And the medical scheme, as you rightly said, then has an additional 3 months to appeal that ruling. I have 6 rulings, and not one of the medical schemes has ever appealed the ruling, because the cases I submit are there is no basis for appealing them. So the cases that I've submitted, the law is unambiguous. There is no room to appeal. They are stalling is the only reason I can imagine that they take as long to approve. So I'll be absolutely honest with you. I have no idea what happens when they appeal, because it's never happened to me. But I know from I know that sometimes they do, and then in that case, it has to go to a proper court. Then it becomes a proper court case, and then it becomes something that a judge will rule on. And then depending on that judgment, then it can just keep going all the way to the Constitutional Court, I guess. But that so far hasn't happened. 6 rulings and no appeals at all. We've got 100% funding, mostly for biologics, for blood tests, for ophthalmologists. We've got refunds for co-payments, and nobody's appealed. So I don't know, but based on what I've described to you this evening, there isn't really a legal basis for appealing that they have any hope of winning beyond simply delaying the inevitable.
Okay.
Does that answer your question, Dario?
Yep. Yes, thanks very much.
Okay, cool. I see there's one from Colleen there. My daughter needs physiotherapy by instruction, Dr. Feller, but we only have a hospital plan. Should the medical aid pay for this? 100%, the medical aid must pay for it. It may need to be motivated. It will need to be motivated by Dr. Feller and potentially the physiotherapist. And they will provide evidence. They will say the reason this child needs this much physiotherapy, and here is the evidence to support this. It's because of this research study and this data. This is what will happen if this child doesn't get this physiotherapy. It is going to prevent her from risking her mobility, et cetera, et cetera, et cetera. I've only spoken about the Medical Schemes Act and the Medical Schemes Regulation, but there's also the Children's Act. And the Children's Act is equally unambiguous about the rights of a child. And doctors, parents, medical schemes, in fact, anybody involved in a decision regarding a child is required to consider the child's best interests. The best interest of the child is what's called a guiding principle of the Children's Act. And everybody needs to act in accordance with the child's best interests. And then there's also Section 11 of the Children's Act also deals specifically with children with disabilities and children with chronic diseases. And their special allowance must be made for in order to ensure that children can fully participate in all aspects of life. So if not having physiotherapy means that your child will not be able to participate fully in life, go to school, socialize, play with their friends, participate in family life, it is actually an infringement of their rights in the Children's Act. So then you've got two laws supporting, not to mention the Constitution of our country, but those two laws specifically support your daughter's right to physiotherapy. But you don't get to say it. The doctor must motivate for it. So yes, it doesn't matter what plan type you're on. All diagnosis, care, and treatment costs must be paid in full, regardless of plan type.
Okay, great. Okay, there's a thumbs up from Colleen. Okay, thanks very much.
Yes.
And then Leandre, did you want to answer? Okay, did you want to ask another question, Leandre, and then we'll go back to Colleen? There we go. Okay.
There we go. Sorry, trying to unmute on the iPad. Apologies. Kath, thanks. It's very informative. Maybe it's a follow-on from my earlier question. So I get all the motivations, and we're with Dr. Feller as well, and she's amazing, and usually does some motivations. But obviously, with some of it, these reports the medical aids want and further documents that need to be completed, and with that, the doctors, rightfully so, because it does take up time, charge those fees for the completion of those reports. And in my experience, the medical aids decline the charge of those fees, so that becomes for your own pocket. Is that something that we could push harder on back for them to pay for as well?
100%, absolutely. All diagnosis, treatment, and care costs must be paid for the PMB within the scheme rules, and when there's no option, outside of the scheme rules. It's never, and maybe I haven't made this clear enough, and it took me a while to get my head around this as well. It doesn't matter what you say to the medical schemes. They're going to reject your requests no matter what. The only reason you're persisting with the medical schemes is because the Council for Medical Schemes requires you to prove that you tried. So what you do is you send the first email, you make sure that you've submitted all the information they ask for. So that'll include whatever report they want, et cetera, et cetera. You make sure that you've given them what they ask for. You apply, they deny, you reply. And important part of this is me training doctors to know what they must say. So they must say, this child's case triggers regulation 15 IC of the medical scheme regulations, and therefore you must fund this treatment. And then they will decline again. And then you take it to the Council for Medical Schemes. The only purpose of going back to and fro with the medical aid is so that you can register a complaint with the Council for Medical Schemes. There are very, very few circumstances where we've had clear-cut cases, 100% guaranteed that the Council for Medical Schemes is going to order the fund to fund the treatments, and the fund still refuses to engage in a conversation about the regulation, and the fund refuses to approve the application. So don't be put off. And there's some funds, the Med Scheme funds, Fed Health and Bonitas in particular, who've come up with some very interesting deviations. So then they've come up with a brand new, literally in the last 2 weeks, they've come up with a brand new report that needs to be filled in by the doctor. And it includes CRP, which are the measures of inflammation in the blood. And they want to know how many joints are swollen and how many joints are tender to the touch. And they all sorts of things. It's complete rubbish. It's absolute hogwash. It sort of implies that unless your child has a minimum of, say, 3 joints that are affected, they don't qualify for medication, which has no basis at all anywhere in any research, any data, or any law. One joint is enough to risk a child's mobility, which is in a contravention of their constitutional rights, their Children's Act rights, and the medical scheme regulation, patient rights. Don't be deterred by what the medical aids throw at you. Just keep in mind, my child has PMB care rights. Are the scheme rules making it impossible for my child to access those rights? And if the answer is yes, have I tried to solve this with a medical aid? I have. I've tried. I've emailed them 3 times. I've phoned them. It's impossible. They're simply refusing. You go straight to the Council for Medical Schemes. That's why the CMS is there. Don't expect the medical aids to go, oh gosh, I hadn't thought of that. Thanks so much for bringing that to my attention. They're not going to do it.
Okay, so that explains why in the beginning you spoke about confidence and fear, because it's an up and down thing. So what they're trying to do is to put you off so that you give up. And then that's okay, fine. Right, so we just persist. Okay. Leandre, thank you for your question. Colleen, we'll go to your question now. We've got about 5 minutes left of the session. So if you'd like to ask a question, please pop up your hand, and Kath will answer it after Colleen, and then we're going to wind our session down. Okay. If there are any more questions, like we say, we invite you to ask them over email or in the WhatsApp group, and Kath will answer you. Okay, Colleen, thank you.
Hi, good evening. Thanks so much for the information. Yeah, it's all very helpful. So I have my daughter Rosemary, who's 16. She got diagnosed a couple of years ago, and now my son, who's 8, has just been diagnosed by Dr. Fowler as well. And then while I was there with my son, Dr. Fowler asked about Rosemary's, how she's coping at school, because Rosemary was diagnosed with long COVID in April. So she's been really sick, missed a lot of school. So we're going to apply for concessions for her. And so kind of based on what you were just saying now, Kath, about children's rights and all of that, I was wondering, can we apply or ask the medical aid to cover the costs of the educational psychologist assessment? Because to apply for the concessions, we have to go through the educational psychologist to get that all in place for her. So I was just wondering, can we motivate it?
Yeah, I would say absolutely. Colleen, have we been emailing? Sorry, just to. No, not yet. There's a second case that also involves an educational psychologist. Firstly, I'm so sorry. It's a devastating blow to have a second child diagnosed with this disease. I'm heartbroken for you, and I'm really sorry. I hope you're okay. Yes, I think I'd like to give it some thoughts. I've got another case in Cape Town. It's exactly the same scenario. The child also needs, the parents need to pay for an educational psychologist. I think that I need to give it some thought, but yes, I think there is a case for making the medical scheme pay for that, but I just need to give it some thought. I'm not 100% sure. I need to give that some thought. Can you pop me an email to catherine@arthritiskids.co.za?
Sure.
Let me give it some thought for the next day or two and figure out what the approach would be.
Okay. Thanks so much.
No problem.
Okay, so if there are no more questions, I think we can wind down and say good night. Kath, this was incredibly informative. Thank you so much for all the information. And like Dario said, the commitment as well. Would you like to close the session, Kath? And if anyone else would like to say anything, you're welcome to now. Okay, I'll leave it to Kath. Thank you.
All right, well, just thanks everybody for being here. I read a great article. There was an amazing article in the New York Times yesterday, a woman talking about post-traumatic stress disorder. Her partner was beaten up years ago, and as a result suffered the most appalling post-traumatic stress. And she was his caregiver, she was his supporter, and she was writing this article from the perspective of the supporter of the person suffering this horrible trauma, and what that did to her. And I saw so much similarity in what we are all doing for our children and for our families. And I think about the million times that doctors and physiotherapists and occupational therapists and any number of other specialists have told me what I have to do. You know, I know it's hard, but you must do the physiotherapy twice a day, 3 times a week. And you must make sure that she swallows her medication, even though she's screaming and throwing up. And you must make sure that she eats the following. And it is an overwhelming amount of pressure that is put on our shoulders. And I just wanted to remind you that it's just recognize that in yourselves. Make sure that you have the support that you need, because you're not going to be any good to anybody if you don't. And just, it's an amazing thing that we do. So well done. And good night.
Okay, great. Thanks for that, Kath.
Okay then. Cheers, everybody.
Take care, everybody.
Bye.
Bye-bye.